I want to talk today about the process in California to seal and destroy arrest records. Now, the first question is, who is eligible? The answer is you're potentially eligible to destroy arrest records in a situation where you got arrested for a crime but never convicted. So that could be because the DA never actually filed charges because it was what we call a DA reject. Or it could be that the DA filed charges, but the matter was later dismissed in court. Dismissed by the judge, dismissed by the prosecutor, or dismissed because you went to trial and were found not guilty. So you were arrested for a crime but not convicted. If you were convicted in court, either because you pled guilty or no contest, or because you went to trial and were found guilty, then you do not qualify for this relief. Now, the next question is, how do I do it? How do I get this destruction of arrest records? And the answer is, if you were arrested but charges were never filed, so in a DA reject situation, you have to start by filing a petition with the police department that arrested you and ask them to destroy the arrest records. Now, if the police department refuses or they don't respond within 60 days, which is usually the case, then the next step is you go and file the petition in Superior Court. Now, alternatively, if it was a situation where charges were filed in court, but you were never convicted, then you can bypass the police department altogether and file your petition directly in Superior Court. Now, once you file your petition in court, the judge will hold a hearing, and it's called a hearing to determine factual innocence. Now, normally at a criminal trial, the prosecutor has the burden of proving you guilty beyond a reasonable doubt. But in this situation, you have the burden of proving that you were innocent. So it's almost like a trial in reverse. Now, we've done hundreds of these cases across California, and they can last anywhere from an hour to several days. Many times there's almost a mini trial in court where we present witnesses, we present evidence, the prosecutor presents evidence, we argue, the prosecutor argues, and ultimately the judge decides whether in fact you were factually innocent. That is, whether you were wrongly arrested and did not commit the crime for which you were arrested. Now, if you're successful, and we've been successful, we've been very successful in sort of litigating these cases, but if you're found factually innocent, then the rewards are very significant. The judge will order all of the records of arrest sealed and destroyed. Now that means fingerprints, booking photos, police reports, everything gets sealed and destroyed. It gets taken off of your rap sheet, and you can legally and truthfully say in any application for a job, for a state license, for a scholarship, you can say that you've never been arrested. And that's important because a lot of applications these days ask, not only have you been convicted of a crime, but have you ever been arrested for a crime? And if the arrest records are destroyed, you can legally and truthfully say, no, I've never been arrested. So when successful, it's a great outcome for the client. But it's a complicated process. It's not something that you want to do alone. You want to have an experienced attorney who's been through this process many times and knows how to navigate you through it. If you're in this situation where you've been arrested in the state of California, but ultimately not convicted, and you want to pursue getting your arrest records destroyed, we invite you to call us here at Schaus Law Group. Tell us the circumstances. We'll see what we can do to accomplish it for you.